Caleb, we get regular emails from people that are looking for legal advice, and we got one in the last week or so that I would call an unlawful detainer, and I believe it was in reference to his girlfriend living in the home, wasn't it?
That's right, Tom.
And so things have kind of gone south between them. I guess the home must be in his name only. He must be the owner. But I think he was like literally talking about having to move out until she gets out of there.
Well, Tom, that's one of the options you have. So, quickly, the difference between an eviction in this scenario is that in an eviction, you have a tenant that pays rent or has an obligation to pay rent and some other things. This is a situation where there's no tenant-landlord relationship. It's just a family member, a significant other, or a friend who's come to stay on your property for some time, and they've used it as a permanent residence. And now the question is, how do you make them leave when you're ready to have them leave? And they say no. That is what's called an unlawful detainer action. And the most common we see, just like this one, is significant others that are unmarried who live together, and one of the two owns the property and the other one does not. And so what we see very often is that the owner of the property has to file this unlawful detainer lawsuit against the significant other, which is very similar to an eviction lawsuit, and it can cause a lot of strife in the day-to-day life. Because imagine suing somebody that you share a bedroom with, or that you sleep across rooms from each other. You're going to see each other every day. It can be quite uncomfortable. So depending on the nature of the relationship, it could be very wise to leave the property on certain occasions.
So a landlord-tenant eviction, in a sense, is similar to an unlawful detainer eviction. Do they take about the same amount of time, or are they about the same process?
So they're about the same process. They both get something called summary procedure. That's a special term for these possession of property actions. The courts or the legislator has said that possession is such a big issue that we want to make it faster than every other lawsuit in the world. So it usually takes about 3 months, between 1 and 3 months, to resolve these types of things.
Caleb, I guess I've seen too many movies where one of the partners got upset with the other partner and they threw all their stuff out the window into the front yard, and that's just not going to be available to people here in the state of Florida.
No, it's not. You can get in a lot of trouble for doing that type of thing, actually.
Well, and I know that when in a strict landlord-tenant relationship, if we know the landlord cannot change the locks as a form of eviction of the tenant, and in fact, if the landlord did that, the tenant would be entitled to damages equal to be 3 months of rent.
That's right, for each violation.
Yeah, if in this situation, if the boyfriend just changed the locks on the girlfriend and put her stuff out on the front porch, let's say, trying to do right by her, what would be the measure of damages there?
So there's not a statutory measure of damages for something like that. In the landlord-tenant statute, we have the 3 months penalty. In this situation, we have what would be called a common law action against the owner of the property. And that's not statutorily defined by the legislator. That's something that the courts have, over time, crafted a remedy for this type of thing. And there's no hard and fast your damage is X times 3, anything like that for these scenarios. But you have, plenty of common law actions where you could sue the owner of the property for booting you from your permanent residence, and you'd be able to recover damages for that, certainly.
And I wonder how they would measure that, because I just wonder what the measure of damages would be there. Assuming none of her property got damaged, what would the measure of damages be, do you think?
I believe the claim would be something akin to a unlawful eviction, and you're going to get basically your consequential or actual damages for that. So the scenario I'm thinking of perhaps is maybe you had to go stay in a hotel or something of that nature, and you've incurred additional costs, and the court is going to, reimburse you to some degree for those things, even though maybe you weren't paying rent where you were staying to begin with. But there's certainly a claim, and certainly if you were to call the police out, the police are not going to kick them the person out, because then the police are now going to be liable for that type of thing. So you're really in a sticky situation when you're an owner and you let a friend or family member stay there for a long time and they refuse to leave.
I'm curious if, speaking of the police, if speaking of boyfriend, girlfriend, partners, but if the home belongs to the boy and he changes the locks and put the girl's possessions out on the front porch, and she called the police, do you think the police would make him let her come back in, move back into the house?
So that's a loaded question now that we have this new law recently enacted where it's a potential that an owner of property could do that. A new law was enacted in July, and that law says that if an owner presents an affidavit to a police officer attesting to certain things, the police have the option to remove the significant other or unrelated person from the premises. So that would be a potential if they meet the requirements in the statute and the affidavit. If they don't, then the police are going to say, no, this is their permanent residence and you have to let them back in.
My guest today is attorney Caleb Maggio. Caleb, welcome back to the show.
Thanks, Tom.
In the first segment, we were talking about the differences between a landlord-tenant eviction and an unlawful detainer action where you don't actually have a tenant in there. You just got like a partner, and partner one owns the property. Partner two is staying in the property. Partner one wants partner two out of the property. They're not an owner. You know what I'm saying?
That's right.
And so I know landlord-tenant law says that whenever a landlord and tenant are suing each other, this is one of the situations, pretty rare situations, where Florida statutes say the winner's going to get attorney's fees. You got a pure landlord-tenant relationship. They're suing each other. No matter what the issue is, attorney's fees are going to be awarded to the winner. What about in an unlawful detainer action? Are attorney's fees awarded in that situation?
So the unlawful detainer statute says that if judgment is awarded in favor of the filer of the action, they can recover costs and damages, but there is not an attorney's fees provision in there.
Okay. And in a landlord-tenant action, I know the very last step is a writ of possession. It's a court order where it is directing the sheriffs to move the tenant stuff out onto the curb. Is the last step in an unlawful detainer also a writ of possession?
Yes, exact same thing.
Okay. And so we've been doing, I'm always kind of surprised at how many people need an unlawful detainer. I say it often here on the radio show that we monitor which of our videos are being watched the most at our Lawtube channel on YouTube, and we have over 1 million views and 10,000 subscribers. And the number one video out there is, how do I make my child move out of the house? How do I make my former boyfriend move out of my house? And it's, apparently it's a bit, so I'm really quite surprised at how many people have this particular issue.
It is. The two biggest scenarios I see are significant others unmarried or adult children still living in the home.
And have you ever tried using unlawful detainer action to get an adult child out of the home?
Oh, yeah, several times.
And just out of curiosity, what was going on with that adult child when mom and dad are saying, get out, and they won't?
Usually there's some sort of drugs or alcohol involved. Very oftentimes it's a scenario where mom and dad feel bad because son's maybe between 30 and 40 and he's had a rough time with drugs or alcohol and he's becoming rehabilitated, and so he moves back home, and then at some point the parents realize that he's really not trying to rehabilitate himself anymore, and they have to make a tough decision to let him go and make him leave. It's very sad to have to do those actions, but
all right, folks, well, we've got lines open for your legal questions. We'd love to hear from you if you're in that situation, if you've got a landlord-tenant issue, or you've got a family member or somebody living in your home that you want them to move out and they're not going to voluntarily move out, and you want to talk about an unlawful detainer action. We're available to talk to you right now at 4